It is 3 minutes after 11. A pleasant good morning to you. My name is Rennie Bishop. You have in Brunch at 107.7. We did promise you the Prime Minister of St. Vincent and the Grenadines, the Honorable Dr. Gonzalez. Unfortunately, he was called into one of those emergency meetings and unable to spend the time with us this morning. So we weren't able to bring him. He being a longtime friend of the former Prime Minister. If at all he's able to, then we will bring him. It is our pleasure to welcome another scheduled guest this morning. He is Attorney Jouis Kelly. He has been with us before. Attorney, thank you so much for taking the time to be with us. It's good to see you again.
Thanks for having me as always.
It is a morning. You're more than welcome. It is a morning that the nation is in mourning. And while we do that, sometimes you've got to do this thing called chew gum and walk at the same time. Right. You've got more than one issue happening before us. The legislation that folks are talking about is the anti-gang legislation. That is something they're trying to get through, get renewed in the Parliament. And the reason the renewal is because, it was put in there for a specified time. We're getting into the sunset area. And there is a degree of urgency with this. And it will impact not just one area, but many areas as the bill itself and many provisions. Take the time this morning to bring our listeners totally in line with what is involved, first of all, in the anti-gang legislation, the components therein, and what it means for us to get this renewed, us being the country in a hurry.
Right. So, put plain and simply, it's a sunset clause. You did mention that, and that basically means that there's a time limit on the legislation. It's set to expire currently on August 15th, 2016, which is just over a month from now. What we have is the bill called the Miscellaneous Provisions Bill 2016. The Miscellaneous Bill 2016, it deals with 5 separate pieces of legislation. Those 5 separate pieces of legislation are 3 Bail Amendment Acts, the Miscellaneous Provisions Kidnapping and Bail Act, and finally the anti-gang legislation in 2011. All of these legislation had the timeline up till August 15, 2016, sorry. Now, generally, the Anti-Gang Act deals with provisions of whether you are a member of a gang or encourage persons to join a gang. The definition is broad to encompass anything dealing with who is a member of a gang. Now, I know when you started, you mentioned the opposition, to get the opposition on board. There's a reason for this, and that is that this particular legislation deals with persons' constitutional rights, the rights to freedom of movement, and freedom of the person itself.
So that's your special majority you need
exactly.
in this case. Okay.
You need a 2/3 majority to pass this bill. That was done in the past. Now, as an attorney, and you may have known of the Law Association's position on this, an attorney generally, in protecting human rights, will be against this legislation per se for a number of reasons. Reason number one being, it's creating a charge before, and as we will know, a person is innocent until proven guilty. Now, while I know the intention behind this bill is mainly for repeat offenders and for serious crimes to get the criminals off the street. So the First Amendment, for instance, the Bail Act, would have dealt with a period of 60 days, and you had the right to go to a judge to question it. Right now, they've taken that clause away, and it's now 120 days.
Yes.
Now, what this means is, putting it simply, I'm not saying this has happened, but if you have a situation where, for instance, a police officer has a grudge against someone, and even if this person is not a repeat offender, and they charge them trumped up with possession of marijuana and possession of an illegal firearm, automatically that person cannot get bail for 120 days.
It is one of the reasons that I had a problem with it early, because if you are traveling in my car, I give you a lift from here to downtown, you leave a gun in the back seat of my car, I am caught in possession of this gun, I don't get a chance to, I can be held up to 120 days before I see a judge. I mean, this is crazy.
Correct. And that in itself is a problem. Now, the reason being is, as you rightly pointed out, even if you don't have a previous conviction, but you are held with a gun, I know it was recently amended, that even before the 2015 amendment, you'd be charged with 2 offenses for the gun, which means you're caught by the legislation, meaning you are in possession of a firearm, an illegal firearm, and you don't have a license for the firearm. So automatically, the provisions of the Bail Act would have applied. Now, I know we have some persons in in the country who will be of the opinion that, well, let the criminals rot away, etc. They don't have rights. But that's not really a position to take, because when you look at it, there are certain persons, everyone always can talk until it hits home.
Mm-hmm.
I don't know if anyone really knows the conditions of the prison system, remand yard, the lack of space, overcrowding of the cells, non-working fans, all of these things. It's a nightmare.
You know, our priority this morning, of course, is to deal with the passing of the Honorable Prime Minister Patrick Manning, who passed, and we did that in the first hour. But this is the sort of thing why we could not put this for next week, because what we're looking at here, if you take the scenario you laid out, in the one I mentioned, and someone is going to take this length of time before they see a magistrate, judge, whatever, and then you look at the conditions in remand, where someone can be sitting there for up to 10 years in some instances before they are properly heard. You are, in fact, doing a double jeopardy before you start, because the man is already paying the state in time. He's already paying the state then to have his case adjudicated. And if by chance he's found innocent, what happens to this man? His life is gone.
Correct. And the stigma remains there. Even when someone is off, there's always that stigma that comes along. Additionally, what we also have to look at is being involved in the system itself. You're talking of a period of 120 days, which is roughly 4 months, right? Now, dealing with it on a daily basis, you would notice that in the court systems of this country, let's take an example of forensic. If you hold a plant-like substance or gun, you can't just start the hearing tomorrow. It needs to go and be tested because of the backlog. This is not going to happen in a 4-month period. So automatically, you're basically incarcerating persons for that 4-month period without them even having access to justice. Now, the average, there might be a one-off situation where a person may be able to. When you look at these acts that were passed 2011, 2015, and the time period, I know there's also the controversial bill, which was supposed to be the preliminary inquiry bill. That's where we got the Section 34 and everything from. But the intent behind that legislation was to provide masters, to provide magistrates, etc., to deal with the case law, to build certain structures in place so that it will speed up the process. Correct. So the judiciary will have to employ certain judicial officers to hear these matters. You will have paper committals, a number of different things that go in tandem with the Anti-Gang Act and the bail amendments. Unfortunately, as we know what happens in this country far too often, certain provisions have applied. There has been no real evidence of a shortfall. In fact, crime has continued to rise. And that is basically the position the Law Association recently took, where you're taking away constitutional rights of the person. There's no evidence to substantiate that taking away these rights affect in any way a reduction in crime. So based on that, I'm not saying there is no evidence, it just hasn't been laid yet. So I know that was recently what was discussed in Parliament, to get that before the House, before the opposition can agree.
And this is absolutely necessary to listen, as you said, because of the special majority needed here. Exactly. How optimistic are you, in fact, that the opposition will come around to it? One of the reasons I'm asking that is because it is, and you can do the correction if necessary, the party that's now in opposition were the ones who brought it and got the support of the party now in governance, and that's how it became law. So what specifically, from your understanding, is the objection now?
Well, the objection, the reasons I can't particularly fault, whether they are for the reasons is another story, but the reasons given were that over the time frame, the intent behind the legislation was to provide certain information. And once that information was assessed, we will be able to know how successful is the legislation. How many persons who are held have been convicted, how many persons who are held were innocent, etc., so that the country at large will know Well, this is actually affecting.
An assessment period is what is required, and you are saying that the what is being asked for is the proof in the pudding. Like, show me where this worked, and if that is, at least that is what is articulated.
Correct.
Not politics, but articulated.
Correct. Now, the other question which you can ask is, so what information was collected in the 4-year period, etc. But I do know that
German inquiry.
correct.
Yes.
From the debates in Parliament, I do know the Attorney General was raising those things and said he has been in consultation with the DPP, the Chief Justice, to find out these statistics. So I'm sure over time we will, at least, God's willing, within the time frame of the 1 month plus, get some of those figures coming back. Wishful thinking maybe, but we'll see.
Watch and see that. Attorney General Jouis Kelly is with us this morning. It's 14 minutes after 11. 2/3 majority needed to have this passed. There are many components inside of it. Any other objections surrounding this anti-gang legislation that you're hearing? That our audience need to understand why, in fact, opposition is being raised outside of the two you mentioned. One is the part, or also called a performance contract. Show me what you did with this. Show me what you yield, what the yield was from this. And if you can't show it to me, I may not want to do this. And of course, the other one is the political angle. We didn't speak about that. We're not here for that purpose. So, any other problems you see inside of that would cause further delay in this, or objections in this?
Well, it's mainly those two, but the objection which comes from outside, as I mentioned, is from the Law Association and the lawyers, and it's primarily funded in that constitutional right that you have. And when you're infringing upon a constitutional right, you must have good reasons.
Okay.
So it won't have that support.
All right, I want to go into the two areas I asked you for us to look at here this morning. Also, the EBC, the Electric Boundary Commission, because this case that's before the courts right now, I was struck, and I mentioned to you when we spoke earlier this week. I was struck by the statement made by the attorney representing the PNM, at least, and he said, if I went ahead and conceded all the votes post 6 o'clock to the other party, you still lost. Now, when I understood that from the onset, I thought this would not even go a place. It is their right to bring the case. I have no problem with that. But if in fact these figures are presented, that if the party that won the seats, first of all, they are saying, well, if you have a problem with the extension, it should be all the seats and not just these that you're cherry picking. But if it is shown from the EBC box that in fact giving you all the votes, the seats in contention would still be won by the victor. Explain to me, what am I missing here? What is going on here?
Correct. Well, I'll put it twofold. You're very correct in saying that it's their right to bring this petition. It's anyone's right. However, you decided to challenge it is another matter. But as I see it, without getting too much into the merits of the case, that's before the court, it's a situation where the allegations that are being made is the EBC acted illegally. And that's the argument that has to be established. They acted contrary to the Constitution, which says that the EBC has all rights dealing with elections on its own, which deals with the separation of powers doctrine and all of these in a different way. The other thing is, if you look at Section 35.3 of the Representation of the People's Act, it specifically says that if an election cannot be held to be wrong if any decision is taken by the returning officer, except if it can be shown that it would materially affect the results. So I think that is where we see the attorney for the PNM is basically running the argument.
And this is not the first time that argument was made. I remember when charges came up the very first time, and these had to be articulated because there was a time to submit, this claim to the courts. Hence the reason one of them was struck out because it came in too late. So the argument was made early. And to have this continue, I am just totally lost. And I thought I would get a legal brain inside of here to explain it to me. I've got a small little pea brain, and sometimes I need clarity. That is still confusing to me.
Correct. And basically, the two arguments were being run at all different parts of this, even from the leave stage. But the court were of the opinion that there was sufficient to deal with the merits of the case going forward. Whether we cross the threshold on the merits, that's why I'm saying it's twofold in my opinion. As far as my reading and everything goes, it would be to establish one illegality. But even if it is that you establish the EBC acted illegally, the other question was, okay, well, did it act illegally, but did it materially affect the result to call it null and void? So those are the two things that I think have to be established. So when it is we're saying now, you're hearing the reports of, but even if all these votes were to go one way, which is a remarkable thing, even if all these votes went one way, it wouldn't have changed the results at all, in the least, in any of the five that remain to be contested. So that's a matter for the courts to decide. I'm sure we'll all see where it goes, but it's quite interesting to see the arguments that are being made.
Very interesting indeed. I want to thank you for coming in this Sunday. I do want to ask you one thing: the Law Association's position on the proposal from the proposal to increase, because my next guest is going to deal with this specifically. But the Law Association position, if they have one on this question of the speed limit, anything articulated there?
I'm almost certain they are discussing it. I haven't seen it, to be quite honest, but I'm sure it was something that would be discussed.
All right. Just something that I think our listeners, the anti-gang legislation, I should say, something our listeners would need to be clear, and I'm glad you stayed back just for the minute for me, Attorney Kelly. When you speak of a special majority, people need to understand why a simple majority will not do in such a case. You alluded to it earlier, but I think it is deserving of a repeat. When is a special, or what's the primary consideration behind a special majority being needed to change legislation in the country?
Yes, that's when constitutional rights are being infringed, or any parts of the Constitution. So, as I mentioned earlier, you're dealing with the constitutional right to the freedom of the person. But additionally, there's also the separation of powers doctrine. The judiciary is an independent arm of the state, as the government is an independent arm. When you're dealing with the government, and the government is stating the judiciary, which had a say and discretionary power before, is also being removed, you will need a special majority to do that, because it's infringing upon the separation of powers doctrine potentially.
I got you. Thank you so much. You have yourself a wonderful day.
You're most welcome, and thanks a lot as always.